to the Web3 Prof Podcast.
Good morning and good afternoon, everyone. I am here with Dhawal Sharma, who is Senior Director, Institutional Legal at Coinbase. Thanks so much for being with me here today.
It's a pleasure being here. Thanks.
So, like a number of my podcast guests, we are neighbors. We live in some kind of weird crypto community or something. Anyways, that's how we originally met, through a neighbor. But for context, let's get an understanding of your background, because you're at Coinbase now, but obviously you didn't start out there. So how did your legal career get launched, and how did you get into crypto?
Yeah, no, absolutely. Well, look, first, it's a pleasure being here. First podcast, so excited to be doing it.
Oh, yes.
Yeah, let me just give you the whole story here, and it's not that long, but I think it helps provide context for where I am in my career today and what I do at Coinbase. So I'm a lawyer. I went to Columbia Law School, graduated. I worked in the government for a bit in DC, most notably at the Securities and Exchange Commission, the SEC, which is a notable player in the crypto space these days.
Yeah.
So I was there for 2 years in a policy role and enjoyed my time there. It was around that time that I noticed there was a lot happening in New York with the NYAG, and they had just brought a case against Barclays for some actions that they had done in their dark pool, which is a type of trading mechanism for institutional traders. And I thought, wow, I had no idea that NYG was this active in institutional trading.
Just for context, what is NYG?
Oh, sorry, the New York Attorney General.
Good.
And so I applied for a job there, ended up moving to New York, went from the New York Attorney General. I did a couple of years at the New York Attorney General. I did depositions. I did a lot of investigations, learned a lot about litigation and investigations, and then moved from there to Goldman Sachs. I was at Goldman for 1 year. I was in a regulatory group there, loved my job. I was learning so much about the guts of trading systems and how it works, and the back-end operations and the front-end operations, and the way that traders think and how regulators think in response to various investigations that they're running. And out of the blue, I got a call from a classmate of mine from high school, and he told me he was starting a cryptocurrency broker dealer, and I had no idea what any of that meant. I didn't really know what crypto was, and I didn't know how that would fit into the context of a brokerage operation, which I did understand from traditional finance. Yeah. But I met the team, and they seemed really stellar, and I thought, in a year from now, if I'm sitting at a row of lawyers at a big bank instead of at a startup, rolling up my sleeves, I would probably regret it. And so I jumped in, and I was the first employee at a company called Tagomi. Tagomi was an institutional broker, and we can dissect what those terms mean as we go on here. But we grew the company to about 20 people. It took about 2 years, and with our good luck and with our hard work, Coinbase ended up acquiring us in 2020. And so I joined Coinbase in August of 2020. I've been there now for 3 years. I've played various roles. I've had various hats in the commercial team and the product team, and now I inhabit a role that has product, commercial, and regulatory aspects, all within the legal world. And it's been a fascinating journey. And suddenly, in the blink of an eye, I've been in crypto as a lawyer for 5 years, which is something I never would have told a younger version of myself and have believed it. But it's been a fascinating space, and I've loved it.
So along the journey, did you become like a pro crypto guy or a Bitcoiner or something like that? Or did that happen before? I guess it didn't happen before you joined, because you said you didn't really know a lot about crypto beforehand. Yeah, no, that's a great question. In many ways, I think that the evolution of my thinking on crypto is probably like a lot of lawyers who have joined the crypto space. At first, from a distance, it seems like very fascinating. The intersection of law and technology is always challenging. It always presents really novel issues. Crypto has that times a million. And so for us, what we end up falling in love with, what I end up falling in love with, is the gray area, and how do we solve for that from a policy and legislative and legal perspective. That's what I love more than anything. The utility behind crypto, the benefits of the technology, the use case as a financial instrument, all the extrapolations that we now have in DeFi, all of that stuff is, to me, intellectually fascinating. As a user, it's great, but my passion really lies in kind of like the intellectual, legal intersections of crypto more than anything else. Excellent. Can you provide us with kind of an overview of the regulatory environment in crypto right now? And I think when we talked about doing this podcast a few months ago, things have changed a lot and become a lot more interesting in this way. So give us maybe what's going on in the United States, which I think is an important conversation, and internationally, a bit of a summary.
Yeah. Well, happy to do that. So I'm an American lawyer, and I practice in the American sphere, and so that's my main focus area. But the international context that you're asking about is so valuable here when we think about what's happening in America, because it is in stark contrast to what's happening in America. And let me just take us back a few years, if that's okay, because I think the historical context here is so important to understanding what's happening today. For intermediaries, big exchanges like Coinbase, like Gemini, and others in the US, the way that regulations have worked historically for years and years and years is that we adopted a model of applying for money transmission licenses in various states. And so companies like Coinbase, my company that I was at previously, Tagomi, Gemini, and other players, we have money transmission licenses in up to 40, 45 states. There's some states that don't have licenses that would apply to our business. And this is a bit odd because the money transmission licenses are historically, they've been applicable to Western Union and payment systems rather than financial intermediaries like a Coinbase or some players like that. But it was a system that we bought into, and a lot of states thought that this made sense because users were sending us USD fiat currency, and their rules applied to the transfer of USD. And so in exchanging a Bitcoin for a dollar, or even in some cases a Bitcoin for Ethereum, which doesn't involve a dollar, the states took a view that their money transmission laws apply to these intermediaries. And so what we've had in the United States is this sort of balkanization, fragmented regulatory framework, where we have to comply with, up to 50 different regulatory licenses. Each of those states has uniquely different sets of rules. There's exams and audits, and it all ends up being kind of burdensome. And some states even have their own specific crypto rules that go beyond this money transmission license regime. Like, for example, New York. New York has the BIT license regime. I think folks have heard about that. It's kind of the more well-known state virtual currency licensing regimes. This is different than a lot of other places, right? So when you look at other countries like Germany, France, Canada, actually Canada's maybe an exception because there is some fragmentation on the provincial side. But if you look at the other countries, France, Germany, Australia, there's a national system. Yeah. And for big players like Coinbase, or even for small players like the previous company I was at, Tagomi, dealing with state-by-state regulation is really cumbersome. Yeah. And it's really taxing. We would prefer, many of us would prefer, and I think Coinbase certainly prefers, a federal regulatory framework. During the years leading up to where we are today, there was no available regulatory framework at the federal side. The CFTC, which is the Commodities Future Trading Commission, which is one of the prominent federal financial regulators in the United States, does not have authority over this space. Their name comes up a lot. Yes. Because what we're talking about often is classified in the United States as commodities. Bitcoin is a commodity, Ethereum is a commodity. The CFTC has authority over commodity future products, commodity derivatives products, like a future that's based, or forward contract that's based on Bitcoin, but not a spot transaction that's just based on a Bitcoin for a USD transaction. So they don't have authority there. The SEC, the Securities and Exchange Commission, only has authority over securities. And the view historically has been none of these assets are securities. The current chairman of the SEC, Gary Gensler, in fact, in testimony before Congress, has said things like the SEC does not have appropriate jurisdiction and appropriate authority over the space. And that's the way that we've all operated. CFTC has no authority. The SEC has no authority. We're dealing with this on a state-by-state basis. Yeah. There's been a change. And the SEC, under Gary Gensler, has shifted the winds, and they've done a very dramatic about face. And now they say that there are securities laws, the federal securities laws, that apply to companies like Coinbase because the assets that we trade, many of those assets are securities. And that's different, and that's different than it's been historically. It's not something that we agree with. And I could walk through what our position is on that and how we think about this, and it's very involved and very detailed. But that's a long-winded way of telling you this is why we ended up here. Yeah, because there's been a lot of murkiness and ambiguity with respect to the law. Right.
So in the scenario that so Coinbase is in a lawsuit with the SEC right now, And is this going to take years to figure out?
It's a great question. So Coinbase was sued by the SEC. Their complaint was handed to us a few weeks ago. We vehemently disagree with it, and we'll be responding very soon with an answer to that complaint. These things are unpredictable in how long they can last, but I think it's fair to say that this might be a long-lasting item that we have to deal with for some time. Getting into the specifics of the lawsuit, if that's okay. The SEC is really asking one question and one question alone, which is, do the assets that Coinbase trade, are they securities?
Right.
So it really just turns on that. And this is in stark contrast to some of the other SEC allegations that have been brought recently against other players. There was a Binance SEC lawsuit that was also brought around the same time that the SEC sued Coinbase.
And Ripple's been in a lawsuit for
years.
For years,
and it's still ongoing.
Yeah.
And so there's a lot of allegations in a lot of these lawsuits, and we don't need to go into all of those. With Coinbase, it really is just one thing, which is should we have been registered as a securities broker dealer, as a securities exchange, as a securities clearing agency, because the assets that we're trading are securities.
But don't we know already that Bitcoin is Bitcoin been categorized as not a security?
I think the SEC would say that Bitcoin is not a security.
Okay.
And they would take that view. But Coinbase has 240.
The rest of them that are the problem.
Yeah, so 240 or so assets that we list for trading on our platform. To list those assets, we have a very comprehensive and robust process that analyzes whether the asset is or is not a security under U.S. securities law. And there's a case here, the Howey Supreme Court case, that we use as one of the main litmus tests for deciding whether an asset is or isn't a security. And we only list assets that are not securities after we go through this very robust process. You know, what's interesting here is that before Coinbase went public, Coinbase Global Inc. is the parent company of our main operating exchange. It is a public company. It's listed on NASDAQ. We went public in 2021. Just want to make sure that that's right. Yeah. We went public in 2021. And as a part of that process, the SEC asked us so many questions about our business. There was robust back and forth. And we sent them, in fact, a lot of examples and a lot of materials related to our asset review process that analyzed with specificity whether certain assets were or were not securities. There were times during the diligence process with the SEC before we went public where we were sharing with them materials that said, we are going to list this asset, and here is the results of our analysis. And there was never any feedback. There was no negative analysis from their point.
Yeah.
There was nothing from them that said, you can't do this, these are securities. And in fact, the complete silence but in fact, what we got was complete silence. And in fact, what we got was an approval later to go public.
Right.
The SEC says today that when they're analyzing whether a company should go public or not, they're not looking at their underlying business for compliance with the securities law. What they're looking at is whether investors will be harmed by this company going public and whether the disclosures that we have as a public company are appropriate.
But wouldn't the investors be harmed if you were indeed illegally allowing securities to be traded?
And that's our view. Our view is that the SEC, I think, is speaking out of two sides of their mouth here. And I think that by allowing us to go public, by approving our direct public offering as a public company, there was a sort of tacit admission from them that our company was operating in an appropriate way.
Yeah. So it seems like the SEC has kind of given you a nod, or given the industry a bit of a nod of approval to say, okay, yeah, a bunch of this stuff is not securities by allowing you to go public. What's happening behind the scenes here? I mean, you used to work for the SEC. How is it that now all of a sudden they're like, actually, we're not comfortable with this anymore?
Yeah, look, I think that there's an incredible amount of murkiness with respect to the SEC and how their rules would apply to digital assets. It's this confusion and it's this lack of clarity that has pushed Coinbase to make so many public statements and file so many documents that we have filed. Just to highlight one of the points of confusion, the CFTC, which I had mentioned earlier, is the Commodities Future Trading Commission, has taken the view that Ethereum is a commodity.
Okay.
The SEC kind of equivocates on this point. They're not willing to commit to whether Ethereum is or is not a security. And some of your viewers may have seen a clip of Gary Gensler, the chairman of the SEC. He was recently testifying before Congress. And in that testimony, he was asked point blank by one of the Congress people whether he thought Ethereum was or wasn't a security. And he couldn't answer with a straight answer.
Right.
It kind of just shows that there's just so much confusion here. And so what we really need, what we want more than anything, is just a clear rule book and a clear set of regulations. And there's a lot happening on the Hill in DC to try to provide that regulatory framework so that companies like Coinbase can operate with known rules and with a known rule book. We actually filed to the SEC a petition for rulemaking where we asked them to make rules that would apply to cryptocurrency intermediaries and cryptocurrency platforms like Coinbase so that we can understand how the new rule book works, how securities laws would or wouldn't apply to cryptocurrency intermediaries and cryptocurrency platforms. They never responded to that petition. And instead, what we got was a lawsuit.
Right.
It's notable here, we are actually also suing the SEC in turn for their lack of response to our petition.
Okay.
We're taking the view that lack of response is inaction.
Yeah.
And that inaction is illegal and that they have an administrative obligation to respond to our petition.
Oh, wow.
And what's notable here is that this case has gone to what's called the Third Circuit in the United States. So there's all these circuit courts that are appellate courts in the U.S., and we filed this case against the SEC in the Third Circuit. The Third Circuit actually responded to the SEC on the day that the SEC sued us.
Okay.
And what they said is, you have said to us, the Third Circuit, with respect to this petition, that you don't know whether you're going to respond to the rulemaking petition that Coinbase filed.
Yeah.
That you're still deciding whether there should or shouldn't be a response to this petition about rulemaking for crypto. At the same time, you're suing Coinbase and saying that they have violated your rules. Isn't that tantamount to saying that you've decided that there is no need for rulemaking, that their petition should be denied? What Coinbase is asking for is not a certain outcome on the petition. What
Right.
we're asking for is a yes or no answer on the petition.
Right.
And the Third Circuit, in response to our suit against the SEC, said, this is a bit funny. And so they actually asked the SEC to provide a response to that. The SEC said that they needed 120 days to respond to our petition. And so we're all kind of waiting with that. And
So we're still within that period.
we're still within the period. That just started ticking. But it just goes to show that there's such a dynamic playing field here. Just stepping back, we've got some regulators saying that certain assets are securities and other regulators saying that those same assets are commodities. We've got petitions for rulemaking that are now the subject of lawsuits with circuit courts. We have the SEC suing Coinbase and Binance and other players saying that the assets that we trade are securities. They have specific lawsuits against issuers like Ripple with respect to XRP and whether that asset is a security. At the same time as all of this is happening, there are really well-developed and advanced bills in Congress that try to provide clarity for this space and try to provide a rubric for the SEC to make rules that would apply to crypto, for the CFTC to have jurisdiction over this space. Basically, at the same time that the SEC is suing us, Congress is deciding what jurisdiction should apply to the SEC for these assets. There's just total confusion and a complete muddling of what it means. And for players like Coinbase, what we want more than anything is clarity.
Right.
We want to follow the rules. We just need to know what the rules are. And in many cases, we don't think there are rules. We think that there needs to be rule making. And that's why we support a lot of the congressional efforts that are happening in the U.S.
So how do things now look? Because, I mean, just even this week, we see BlackRock filing for a spot Bitcoin ETF. I had read, and I'm not sure if this is true, but that they have filed for 500 and some ETFs in the past, and only one has ever been denied. And so we and a whole bunch of other organizations in the same time frame have kind of gone pro Bitcoin in just like a week's time. So how does this impact the SEC's decision and Coinbase in the lawsuits that you guys have?
It's a very interesting commercial development. So BlackRock filed what's called an S1 statement, a Form S1 with the SEC, and at the same time NASDAQ, in correspondence with BlackRock, filed what's called a 19B4. Together, what these filings mean is that they are seeking to have a cryptocurrency, Bitcoin backed, 100% backed ETP, exchange traded product, traded on a national stock exchange like NASDAQ. This would be a huge development in the space. And as a result of BlackRock doing that, BlackRock is a $2 trillion asset manager. They're one of the biggest, if not the biggest asset manager in the entire world. So by them getting in line, a lot of other players have followed suit, and we saw Wisdom Tree filed for an S1 ETP in conjunction with SIBA, which is the Chicago Board of Options Exchange. It's kind of like the Nasdaq BlackRock. There's now this other one, and I think we can expect there's speculation that there may be more that get filed in due course. I think what this shows is two things. One is that there is a nod and endorsement from some of the biggest players in the traditional financial sphere for working with players like Coinbase and for acceptance of Bitcoin as a dominant asset class. I
had read that Coinbase is the custodian for BlackRock. Is that right?
That's right. Yeah, we're named as the custodian. We're named as a prime broker for trading as well. And so in our minds, this is a huge win for Coinbase and an endorsement of Coinbase and the value that we bring. But it also shows, I think, for players like BlackRock, for players that are traditional financial institutions, there is an interest and there is a desire to have cryptocurrencies become a part of the mainstream of the financial sphere. What does that mean for the SEC? To your question, it's hard to really say, and time will tell. And the SEC has a lot of time to evaluate whether to approve or deny this ETF filing. There's obviously a notable ETF filing that currently that's percolating through the appellate courts. Grayscale has a suit against the SEC. Their conversion to move from a trust to an ETF was denied by the SEC. They have sued the SEC. We expect a decision on that relatively soon in the next few months. And so all of these data points, I think, will be valuable in helping us define the SEC's jurisdiction in this space. And I think we have a certain view that there are areas where the SEC should have jurisdiction. One of those would be with respect to exchange traded funds. Those are securities. And there's no basis to deny a Bitcoin ETF.
But why have they denied so many then?
So I don't want to go into that. If that's okay. Yeah,
that's fine. Yeah. So if they say, if they approve, or do you think the SEC is sitting there thinking, okay, if we approve the BlackRock ETF, and we've already allowed Coinbase to go public, and here are some kind of positive things we've done to support kind of the crypto movement, we need to deny BlackRock to kind of solidify our position against Coinbase. Is that come into the thought process of the SEC?
It's possible. If I was the SEC, I would be thinking about these things in a holistic way.
Yeah.
But it's hard to know what's happening on the inside. It's a complex institution, and there's many different layers of thought process. Needless to say, from the outside, we are looking at this in a holistic way, and we think there are areas where the SEC should have jurisdiction. One would be a BlackRock Bitcoin ETF.
Why do you think? So in Canada, we've had a spot ETF with Bitcoin for maybe 2 or 3 years. For sure more than 2 years now. And I believe that there are a few other countries that have such a product. Is it the confusion around regulation in the United States that has stopped this from happening in the United States?
Yeah, it could be the confusion. It could just be that the securities laws in the United States are just a little bit different than they are in other countries. In many other countries, and I'm not a German legal expert, but in German securities law, in German financial law, there's a term of a financial instrument or something like that, like a financial instrument, and it's a generalized term, and the regulator could just make just have a view that cryptocurrencies are financial instruments, and therefore the rules that we have for financial instruments apply to cryptocurrency. With the United States, there's a very particularized test for whether an asset is or isn't a security, and we have this Byzantine fragmented regulatory framework that I was walking to earlier, where we have state rules, we have federal rules, and within the federal system, there's bifurcation. That's relatively unique, and a lot of countries don't have that. Even in Canada, where you have the provincial breakdown, there's the OSC and in Ontario, there's the AMF in Quebec. There's still at the federal level, there's guidance provided, but there's not disputes at the federal level between two different federal agencies.
I see.
And the United States has something that's a little bit more complex.
Yeah.
I think until the United States can bring this together in a holistic way, I think we'll continue to see kind of 2 steps forward, 1 step back in what's happening in the product market for the United States. For countries like Canada, I think it's just a little bit more achievable because of of the relative clarity that they have.
Do you think that this is, in the current state, unhelpful to the American consumer?
Absolutely. I think that the lack of clarity is extremely unhelpful. I think the cloud that hangs over the industry's head is harming investors. If you look at Canada, just to take the example that you just provided, the ETF market would allow people that are interested in crypto to have exposure to crypto through securities intermediaries. It would be no different than buying Apple stock, but it will allow people to have that exposure. And that's really great for retirees, for retirement funds, for the average person. Just say, I'm not ready to take that step into Bitcoin, but I am ready to take a step into a Bitcoin-backed ETF. That would be a great exposure. And I think something that, without providing financial advice, I think would be something a lot of consumers would be interested in. That lack of availability in the United States, I think, is something that's harming investors.
Does the SEC look at this and say, okay, well, there's a whole bunch of people that are going to buy Bitcoin. If there was an ETF, they probably would buy that. But by lack of clarity and lack of regulation, we're kind of forcing them to try to figure out seed phrases and wallets and use exchanges that are maybe questionable, and it forces a lot of consumers into an area that they really probably shouldn't be dabbling in. Whereas if they had an ETF, it would kind of provide a lot more guidance and simplicity and things like that.
That's an interesting point. I think one thing I would say about the marketplace today is that for intermediaries like Coinbase, we try to provide that simplicity.
Sure.
Crypto can be daunting, right? Like everything you've said about the seed phrase, like knowing how to operate a multi-computation keys is just so daunting to the average person. Players like Coinbase try to provide simplicity to allow you to access both CeFi and DeFi products, which I think is really helpful. To your last question about the harm to consumers, we try our best to provide disclosures, and I think we do a really good job of doing that. And I think we're industry leading in that respect, and we borrow a lot from traditional financial institutions. We have taken it upon ourselves to do a lot more than what is required of us. There are other players in the crypto space that perhaps are not as scrupulous, and to your point, to say the least. And so to your point about are investors harmed? Yeah, absolutely. And I think if there was clarity from the agencies, if there was a clear rule book, then it would be a lot easier for consumers to know what disclosures to look at. They'd have more known paths to file complaints with federal regulators, things that they can do today when they're trading Apple stock on E-Trade or whatever, but things that they can't do today because the SEC just doesn't have the jurisdiction over this space.
I apologize if you can't comment on this, but I want to ask, if the SEC had provided more clarity, are challenges like the collapse of FTX avoidable? Is FTX really a result of the lack of regulation in the space?
I'm happy to comment on that. So it's hard to say, but I think one thing that we can say is that if we just step back, the U.S. market really is coveted, I think, by a lot of international crypto players. They want to be here. They want to establish their roots here. It's a relatively small market, and we're talking about 350, 400 million users. That pales in comparison to a place like China or India. And so the question is, why do they even care about the U.S.? And I think there's an achievement and there is a approval stature that you get by making it in the U.S. It's hard to make it in the U.S. given the murkiness of the law here. And I think the lack of clarity and the lack of clear rules have driven some players to be offshore. FTX was largely an offshore entity. 90% of their trading and 90% of their customers were offshore. If FTX was onshore, would some of this nefariousness, would some of the commingling and lack of ethics, would that have been ferreted out by regulators? Potentially. There have been failures in the U.S. as well, and Bernie Madoff and everything that happened there is a good example of that. FTX, of course, did have a U.S. arm, right? And FTX U.S. was not harmed, and the FTX U.S. users were not harmed in the same way because there were rules on the state-by-state side that forced them to have a backing of their customer assets in an appropriate way. I think FTX was forced in many ways to go offshore because of the lack of clarity. And if the United States had more clarity and they invited more cryptocurrency players into the space in the U.S., I think the results would have been much better for users.
How do you, as a lawyer working in regulation, deal with the fact that crypto kind of was started with the vision of kind of lack of regulation, or kind of like, hey, I want to control my stuff and I don't want the government to tell me what I can and cannot do. It's really part of the core ethos of Satoshi Nakamoto and the creation of Bitcoin. Whereas a lot of people from centralized exchanges like Coinbase are saying, well, we need regulation or we need guidelines in order for this to move forward, which, there's a bit of a paradox there.
Yeah, no, I think there is a bit of a paradox as we sit in this hotel called the Paradox Hotel.
Oh yeah, that's right. I didn't think of that.
But I think crypto is a complex asset class that different users will use in different ways, and I think that's okay. There are some users, like we were talking about earlier, who want the central intermediary that can hold their seed phrase for them. That can just log in as if they log into their
Facebook,
their Facebook account or a Scotiabank account, and it's no different.
Yeah.
But there are other users that want some of that original thesis that started and generated and made crypto flourish. They want that experience. Not to make this like a pitch for Coinbase, but we want both of those sides of crypto to really thrive. And I think we try to do a lot for the latter half as well. That's not something that my legal team works on as closely. There are lawyers at Coinbase who are working on enabling just that sort of thing. The ability for a user to take their assets and deploy them into DeFi with their own wallet, with their own keys, and not have Coinbase involved at all. But we can provide a window into that and an ability for users to do that. As these things both thrive, and they will inevitably have feedback with one another, and I think they will both grow in their appropriate way. So, is regulation valuable? Is it important? It certainly is for the central intermediary side of the equation. I think as that gets a better paved path as time goes on, I do think that it will have positive feedback for the DeFi side of the world.
You had mentioned that you're involved in the product side of the company as well. What does that look like, or what does that mean?
Yeah, so the business that we cover is institutional business at Coinbase, and so what that means is we are supporting our products involving the trading of cryptocurrency on our exchange, the trading of cryptocurrency on our broker, the custody of cryptocurrency, and a bit of and also things related to the derivatives and use cases of cryptocurrency in the derivatives market and internationally. And so the role of a product lawyer at a place like Coinbase is to help the business decide, how do we launch these various products? We want to launch a new type of trading contract. What are the regulations? What are the things that we should think about? How do we navigate all that? We help them bring that to market.
Okay. And so when we think about Coinbase as an American organization, as a Canadian using Coinbase, how does Coinbase deal with the regulation of other places that it's operating in?
Yeah, we have this outstanding international legal and policy team that is literally all over the world at any given time. They're based in London and Singapore and other jurisdictions, and we have relationships that we are developing with regulators globally to help them understand what Coinbase is about, what the cryptocurrency sphere is about, and how do they define regulations in a way that will allow innovation to grow and not put us back. And this is a challenge because I think for a lot of regulators globally, including in the United States, but globally as well, this is a new space. A lot of them have no idea what cryptocurrency is. They don't understand why the regulations that they've applied for tens of years, hundreds of years, why should those be different from crypto? And that educational process is something that we take a front seat in, and our policy team is really driving that forward. Our lawyers are helping craft that. They're very busy. And the reason that they're very busy is because internationally, there are so many regulators who are forward thinking.
Right. Okay.
They want to get it right. And they're putting in place regulations that will allow consumers to be protected and cryptocurrency intermediaries, cryptocurrency platforms to have rules with which they can apply and launch their products.
Interesting.
Do
you have any indication of where these progressive places are?
Yeah, and they're not always progressive in the sense that they're favorable to the crypto intermediaries, but more than anything, they provide clarity.
Okay.
And that's really what we need. It's just what are the rules, and we will follow them, right? A good example of this is in the EU. So in the EU, they recently passed a rule called Markets and Crypto Assets. It's the acronym is MiCA. And MiCA is going to be implemented relatively soon. It provides a rule book, an AML guideline, a known disclosure regime so that players like Coinbase can offer their products to EU residents. And there's finally clarity there. There's clarity that's emerging in Hong Kong right now. There's clarity that's emerging across Canada. And Canada has actually been one of the countries that has done, in our view, such a fantastic job of being collaborative with the industry, trying to understand the pain points and trying to help them adopt their rules to the cryptocurrency sphere. And we've had great relations all across the world. I'll also say, just coming back to the United States, when we are the door is wide open at Coinbase to have further dialogue with the SEC and other regulators, and we regularly are having those. It's unfortunate that what we're dealing with right now with the SEC is a lawsuit in addition to the conversations. It
seems like if you would ask the common person, Coinbase is this big of a company. If they call the SEC, do you think the SEC is going to call them back? And people will be like, yeah, probably. I mean, they seem like a pretty big deal. But I get the sense from you where it's not like that at all, where you guys are pursuing a relationship with them and they're kind of like, we don't really want to really talk about this. Am I right about that?
Well, so we actually, we had a series of conversations with the SEC recently leading up to this lawsuit. We were trying to provide a view about what a market structure could look like for crypto as applied to securities law. And we spent a lot of money with outside counsel preparing for these meetings and providing them with the presentation. And we had meeting after meeting after meeting where Coinbase was doing all the talking. When it was finally the SEC's turn to respond to our various pitches and respond to our proposal, they actually shut the door. The meeting was canceled. And very soon after that, we learned that they were moving from this discussion phase to a investigation phase. And thereafter, we got a Wells notice, which is a heads up that we're going to sue you.
Okay.
And then very soon after that, they
sued you.
Yeah.
Well, that's nice that they give you a heads up. So considerate. Okay, Dhawal, this has been a super interesting conversation. I love kind of learning about the back end of the industry that so many of us are passionate about. It's certainly not a space or the area that you work in that's readily understood or available to the regular Bitcoin holder. So it's really helpful to learn and understand this because, I mean, it's clear the decisions that are going to be made about Coinbase and some of the other things we talked about are going to have everlasting impacts on the crypto space. This has been super helpful. Thanks for being with me.
My pleasure. Thanks so much.
Thanks, man.